to put it on my side. Yeah, okay, so welcome to everyone. So this is one of online seminars on Islam and AI. And today it's our pleasure to welcome Mifrah Hayath, who will be talking about Islam and AI in reproductive healthcare. Yeah, thank you, Hayath, from Mifrah. Yeah.
Assalamu alaikum. Thank you for having me. It's a huge honor to be talking for the Muslims and AI conference at Imperial College London. My name is Mifrah Hayath, and I'm a recent graduate of Harvard Medical School. I spent most of my career in the biological sciences, studying cell mutations and therapies, and really investigating how we can help those who are ill. So it's a bit of a surprise how I transitioned into religion and AI. AI is taking the world over as we speak. It's rapidly being incorporated into different fields, whether it's health sciences or law or policy. And religion was something I grew up being always interested in. I grew up in a semi-religious household. I loved my religion and my faith. And I was really interested in comparative religion. So how can religion and scientific technologies really interact? So throughout my research, I wanted to study how embryos and AI can be held accountable in different schools of law, whether it's Sharia, UK, or US. So thank you for joining me, and let's get into it. So at first glance, embryos and algorithms might not seem like something that would be paired normally, right? It's kind of an odd pairing. But embryos represent our most sensitive frontier. They are potential future lives. Algorithms, on the other hand, meanwhile, are increasingly invisible actors embedded in systems that guide decision making, but often escape scrutiny. Together, they create a new ethical frontier where decisions about life itself may be shaped by probabilistic outputs from machines. The stakes are enormous: accountability, legitimacy, and the future of healthcare ethics. But the guiding question I want us to wrestle with is this. If AI takes on the role of selecting embryos, can our existing frameworks of consent and responsibility keep up? Or do we risk creating a void where no one is fully accountable? So the background is, I don't know how many of you have a background in either science or religion, but just to give a small brief background, artificial intelligence is already integrated into IVF clinics today, but it's not as a futuristic add-on, but as more of a practical tool. So clinicians are using AI to screen embryos for viability. So predicting which embryos are most likely to be implanted successfully. So AI is expanding into genetic screening, into pre-implantation testing, creating a predictive map of an embryo's potential health outcomes. But this raises deep ethical questions. Who ultimately decides which embryos, and therefore which potential lives, move forward? Is it the physician, parents, the algorithm, the clinic, some combination, all of the above? And when things go wrong, whose fault is it? Who do we have bearing the burden, right? So there are three main applications that you should be aware of. We have embryo viability scoring, genetic risk prediction, and integration with CRISPR futures. So embryo viability scoring is a deep learning algorithms that analyze time-lapse images of embryos. So this is allowing us essentially to predict which are the most likely embryos that we're going to implant. Then there's genetic risk prediction, where algorithms now feed into polygenetics risk scores and what counts as a disease prevention versus a trait selection. And then there's integration with CRISPR futures. This isn't science fiction. This is now something that's happening every day. AI is being tested to guide genome editing tools, raising the possibility of AI steering the scalpel at the genomic level. So this convergence of embryo selection and gene editing means that we as a community need to act before the technology defines the ethical boundaries for us. So now we're going to go into the ethical risks about using these technologies and what is being faced on a moral level. So the risks here are not hypothetical. We face three major ethical concerns. First is the eugenics drift. Once you normalize optimizing for health, it is a short step to optimizing for traits slipping towards designer babies. So it's actually similar to a book by Jodi Picoult and My Sister's Keeper that was basically forewarning these issues, that what harms can come from using these types of technologies, again with designer babies and cloning. And second, we have disability discrimination. So we have to ask ourselves, how does this hurt or help the disability community? So embryos with certain markers may be discarded, reinforcing social stigma around disability. And third, we have commodification of life, where embryos become data points with scores attached, marketed by clinics as if they were products, consumer products. These risks show up in clinical brochures and patients' consent forms today, and they're not abstract concerns. So these are the risks of reproduction. We have black box opacity, data set biases that can lead to inequalities. Again, we're not really, the system is not totally foolproof. It can lead to error, which brings us back to the question, who is to blame if that error is to happen? So is it the patient? Is it the parents? Is it the algorithm, the physician, the clinic, the people who develop the software? All of the above, right? And then it's, again, not perfect. So if there's an error, and there's a wrongful birth, what's going to happen to that said patient? So I would ask to take a pause here and ask the audience that, should AI be treated like a lab test or like a co-doctor? So now we're going to go into the different types of law and dialogue that are surrounding these topics. The three I'm focusing on my talk today are Sharia law or Islamic law, and the UK and US law. So to analyze these issues, I'll move between two traditions of law. One is the Sharia, which emphasizes the sanctity of life, preservation of lineage, and the moral imperative to prevent harm. On the other hand, we have the law in the United Kingdom and the US, which focus on liability, consent, and right-based protections, and are often framed through disability rights discourse. Each tradition frames embryos, algorithms, and accountability differently, and each illuminates the blind spots that others overlook. So we'll start off with Sharia perspectives, or my favorite type of law perspectives. Sharia law provides this robust ethical framework for thinking about AI and IVF, which is very surprising because, again, when Sharia law first came into connection with people, AI was not a thing, even IVF was not a thing. But it places a high priority on the sanctity of life and dignity and preservation of lineage and the principles avoiding harm. Within this framework, medical technologies are permissible when they serve these objectives and impermissible when they undermine them. That means the key question is not just whether AI works, but whether it preserves dignity, avoids harm, and aligns with moral intent. This forces us to ask, can an opaque AI tool really serve these purposes if its outputs cannot be explained to the patient? It should be taken into account that normally the patient does not have a background in medical or biological sciences and may not fully understand what's the procedure to the full extent. So this also takes into account autonomy and really the role of the patient deciding what to do with their own body. So now we're going into fatwas and precedents. There are already fatwas guiding IVF practice. IVF is permissible within marriage. Embryo freezing is allowed under specific conditions. Surrogacy is generally permissible. The pressing question now is whether AI-assisted embryo scoring should be treated as an extension of physician judgment or as outsourcing moral responsibility, or taqif. If it's the former, it may be permissible with safeguards. If it's the latter, it risks undermining Sharia's demand that humans morally accountable actors. So now we're going into Sharia and AI accountability. A central Sharia concept here is rida, or genuine consent. So consent must be informed, meaningful, and freely given. So again, going back to my point that sometimes the patient may not fully understand the extent of the procedure or even the technologies involved. So that being said, consent must be informed, meaningfully and freely given. So can an opaque algorithm meet this standard if the outputs are problematic and inscrutable even to experts? So Sharia teaches that accountability, or taklif, can now be outsourced to a machine. AI can be a tool, but never the decision maker. For permissibility, there must be explainability to the patient and a clear attribution of responsibility across clinicians, institutions, and developers, and so on, expanding similarly for, say, UK law framework, case law, US patchwork, comparative consent and accountability models, embryo value, inequality and access, pluralistic framework, and so on and so forth. So again, going into the fatwas that are allowed, IVF is again permissible in marriage between what's considered allowed marriage in Islamic law, so the relations between a man and a woman. Embryo freezing is allowed under certain conditions, but surrogacy, as usual, is not allowed. Again, it's very important that it's under the guise of marriage and that the sperm and the egg are between man and wife. So now we're going to go into the United Kingdom and their regulatory framework. And the UK reproductive medicine is governed primarily through the Human Fertilization and Embryology Act of 1990. And this was amended in 2008. Oversight is provided by the Human Fertilization and Embryology Authority, which licenses clinics, tracks embryos, and sets ethical limits. AI and IVF falls under the Medicines and Healthcare Products Regulatory Agency as a medical device, but there are challenges, right? So the HFEA was not designed with opaque AI systems in mind. Its framework assumes that clinicians understand the tools they use. With AI, however, much of the reasoning is hidden in neural networks. So when a clinician says, this embryo has a 65% chance of implanting, we have to ask, how is that number calculated? Can regulators audit that process? And if not, are patients truly given informed consent? So the UK's regulatory system has clear structures, but gaps emerge when it encounters algorithmic opacity. So now we're going in liability in the United Kingdom, and in terms of legal liability, the UK falls back on traditional categories. Physicians can be sued for negligence, duty breach, causation, damage. If a doctor relies on faulty AI and fails to check its outputs, they may still be liable. On the other hand, software developers could face product liability if their algorithm is defective. But here's the problem. Many AI systems don't fail in a clear binary way. Instead, they make problematic predictions that may be correct most of the time, but catastrophically wrong in a specific case. So in those cases, whose fault is it? The physician for trusting the system, the clinic for deploying it, or the developer for not anticipating bias and drift? These gaps are where the UK law struggles because negligence assumes discrete errors, not problematic uncertainty. So we'll just dive into a few case law examples. Case law provides some useful analogies. In Evans v. UK, 2007, the European Court of Human Rights recognized embryo consent rights, reinforcing that embryos cannot be used without proper authorization. And then we have in Warren v. Care Fertility, 2021, an embryo mix-up led to litigation over mistakes in fertility treatment. These cases show two things. First, the law takes embryo consent very seriously. Secondly, errors in IVF can have life-altering consequences. But how does this map onto AI? If an algorithmic probabilistically misclassifies embryos, does it count as a mix-up? Can proportional analysis, so central to UK human rights law, really handle problematic harms? So I want you to pause and think about whether our legal tools for discrete accidents can stretch to cover algorithmic uncertainty. And now we're going to go close to my home in the US and talk about US law patchwork regulation. The United States has a very different landscape. There is no single IVF law. Instead, regulation is fragmented. So the FDA treats some AI systems as medical devices, but the oversight is inconsistent. So state laws, especially post-Dobbs, create new restrictions around embryos, fetal personhood, and reproductive autonomy. On top of that, much of the fertility tech is delivered through private contracts. So this bypasses stronger federal regulation altogether. What does this mean in practice? So patients often sign lengthy contracts with clinics or fertility tech companies that limit liability and shift the risks onto the family. So if something goes wrong, patients may discover that they waive their rights in the fine print. So unlike the UK, where public oversight is central, the US system is fragmented, privatized, and shaped by litigation. And more case law examples, and Jeter v. Mayo Clinic, the parents sued after embryos were lost due to negligence, raising the question of whether embryos should be treated as property, as persons, or something in between. So in McQueen v. Gadberry, courts grappled with embryo custody disputes, again exposing deep uncertainty about embryo status. So now imagine layering AI onto these disputes. If an algorithm misclassifies viability, who pays? The clinic, the software vendor, parents who signed the contract and apparently read it? These cases show that American law doesn't even agree on what embryos are. Property, life, something else. Without that clarity, accountability in AI-driven IVF is even harder to pin down. So let's compare how consent operates across three systems. In Sharia, Ridda requires that patients genuinely understand and agree, rooted in both legal and moral obligations. Consent is substantive and not just procedural. In the UK, informed consent means the disclosure of material risks guided by cases like Montgomery v. Lanarkshire. It's about what is reasonable, what a patient would want to know, while in the US, consent is often contract-based, more about risk allocation than genuine understanding. The danger is that with AI, opacity undermines all three systems. If the explanation of the algorithm is reduced to, say, trust on the model, it's 90% accurate. But does that meet Sharia's Ridda? Does that satisfy UK's law requirement for material risk disclosure? Or is it buried in US-style contracts? Comparative analysis shows us that opacity is the common blind spot. Accountability also looks different. Sharia insists that humans remain morally accountable. Taklif cannot be outsourced to tools. The UK has a layered system where liability may rest with clinicians or developers, but problematic harms fall through the cracks. The US diffuses accountability, often leaving families with limited recourse. What all three frameworks share is that none of them are fully prepared for a future where algorithms make morally loaded decisions about life. So each has its strengths, but also has its struggles when faced with opaque, problematic, and value-laden outputs from AI. So another key difference is how each system values embryos. So the Sharia law, in Sharia, it sees embryos with a framework of dignity and lineage, subject to moral protection even before full personhood. The UK law often treats embryos as subject to statutory regulation, not full legal persons, but still entitled to certain protections. US law is deeply divided. Some states treat embryos as property, while others flirt with granting them personhood. Why does this matter? Because how you conceptualize the embryo shapes how you respond to harms. And basically, if embryos are sacred trusts, as in Sharia law, AI errors implicate moral accountability. If embryos are property, as in some US rulings, then it becomes a matter of financial damages. If embryos are regulated entities, as in the UK, then the harm is seen as a compliance failure. This very definition of harm shifts depending on the definition and on the underlying value framework. So then we think about even if these technologies were implemented and understood by scientists, clinicians, and patients alike, how does that affect society? So beyond the doctrine, there are issues of accessibility. IVF is already stratified, it's expensive, often out of reach for many families. AI could deepen these inequalities if only wealthy patients can afford advanced embryo scoring. On one other hand, if AI reduces costs and increases success rates, it might democratize access. Again, the key question is who will benefit? If algorithms are expensive, AI may entrench reproductive privilege. If openly shared and regulated, AI might broaden opportunity. Either way, inequality must be part of the governance conversation. So, in this paper and in my research, I argue that there is no single framework is sufficient. AI is not a value neutral. It carries implicit choices and biases. And to really regulate this responsibly, we need pluralism. Sharia provides ethical guardrails around dignity, consent, and accountability. The UK law provides structured oversight and negligence doctrines, while the US law, fragmented, reflects on the reality of privatization and litigation. So together, these perspectives help us see the blind spots. Pluralism prevents us from sliding into, say, this narrow perspective and have these unreflective eugenics. It creates a richer governance framework that takes into account law, ethics, and faith. So just to summarize, I'll end my talk with a key takeaway. AI and reproduction challenges the very foundations of consent and accountability. Sharia insights enrich global debates by insisting on substantive consent and human accountability. And the UK and US law provide important case law and liability structures, but struggle with problematic harms. So across all three, opacity is the common problem where algorithms are black boxes and legal systems falter. This means we must design governance that restores explainability and keeps humans at the center of accountability. So I want to end with a provocation. If algorithms attribute its life itself, how can we stop them from becoming modern idols? Throughout history, societies have been tempted to offload moral responsibility onto forces they barely understand. Today, that temptation is embodied in artificial intelligence. The task before us is to resist the idolatry of AI, treating it as if it was infallible, and instead build ethical and legal systems that keep human dignity at the core. Thank you again for having me. Thank you to the Imperial College of London and Muslims in AI. It has been an honor and privilege. Jazakallah.
Yeah, thank you very much. Are there any questions from the audience?
Can we stop the recording, please?
Yeah.
Any questions?